My name is Barry DeWalt. I am the city attorney for the city of Reading, and I have been city attorney since May of 2015. With regard to the Surplus Land Act, it's been on the books since 1968. However, in 2019, the laws changed to make the act a lot more rigorous with regard to allowing opportunities for affordable housing. So what that means now after 2019, all property before it can be sold or put out to long-term lease must be declared either surplus or exempt surplus. And for our purposes, it's not really necessary to go into what is exempt surplus. It's a laundry list of some very specific narrow exemptions, but surplus property is essentially property that the agency has determined is no longer necessary for agency use. What it does not mean is that if a property is declared surplus, that it thereafter must be sold. It means that it may be sold. And so that's an important distinction. So the council has to begin with the process of determining whether the property is exempt surplus or surplus. And it does that by making written findings that the property is no longer necessary for agency use. It does that by resolution. And after that, what happens is we have to send out notices of availability to housing providers. Housing providers in the state can get their names on a list with the Housing and Community Development Department in Sacramento, state agency, to receive these kinds of opportunities. And so we have to make all property that is determined as surplus available to these agencies for a period of 60 days. If one of the agencies determines that they would like to enter into negotiations for the purchase of the property, we have an obligation to negotiate in good faith for a minimum of 90 days with that provider. Doesn't mean that ultimately you must sell the property. Once again, it means that we have an obligation to negotiate in good faith during that period of time. If nobody responds to a notice of availability during those 60 days, or if somebody does respond but negotiations fall out because the parties are too far apart, then at that point the property can be offered for sale to anybody else, and the city could then and only then begin negotiations for the sale or long-term lease of property. So that's an important distinction. So there's a significant amount of process that has to occur prior to any decisions about what to do with the property, whom to sell it to. This is the beginning of the process. It cannot be, by law, the end of the process. So that's really important for the public to know. And you know, we've heard comments during the first couple times that this issue has been raised publicly, that it seems like a lot of members of the public think that the city council can just decide on a Tuesday night at a regular meeting that they're going to sell the property. They can't. We have to follow this process before that can even occur. And that's why the workshops are really helpful, because it allows the public to engage with their elected representatives, and that's important because this other process can either go concurrently with that or after the public engagement with regard to surplusing the property. So we have time. We should take time. The law requires that we use the time, and that's essentially the Surplus Land Act in a nutshell. The immediate concern for the public is that they should have input on whether property should be sold, right? It's public property, it's in the public trust, and they should have input on that. That is what the Surplus Land Act is intended to facilitate at the initial meetings when a resolution is adopted to say that the property is surplus. So it's important because it encourages public engagement and it encourages affordable housing opportunities. So that's why the public should care. With regard to the property down at the riverfront, the Surplus Land Act is important because it's important to note that it creates a bunch of process so that nothing can be done immediately just on a regular council meeting on a Tuesday night. The council can't suddenly decide, yeah, we're going to do this with the property. We're going to sell it to this entity. That's simply not possible under the Act. So it's important to note that the Act forbids negotiation for the sale of property until the whole process of surplusing land has accomplished, which means adoption of a resolution saying that the property is no longer necessary for agency use, providing 60 days of opportunity for housing providers to say that they're interested in the property, and then allowing another 90 days for negotiations for that property. So all that has to occur before anybody can negotiate the sale of public property. And that also applies to the riverfront property.